Hello, this is Attorney Brian Pendergraft, and you are listening to the Ask a Real Estate Attorney podcast. And for this first episode, I'm discussing what are the elements of a real estate contract. And disclaimer, this is legal information, not legal advice. For legal advice, contact a licensed attorney in your jurisdiction. So, most states have a statute of frauds that require real estate purchase and sale agreements to be in writing in order to be binding. And here is what just about every real estate contract should contain. Um, element number one, an offer. A real estate contract must contain an offer. An offer is I'll buy your house for X amount of dollars. And the person who is making the offer is called the offeror. Generally, the buyer is the offeror, but the seller can be the offeror too. They can say, "Hey, I'll sell you my house for X amount of dollars." At that point, the seller is now the offeror. Now, the second element is in what is called an acceptance. An offeree can accept the terms of a contract, generally by signing it. If an offeree makes any changes to a contract before signing it, then it is no longer an acceptance. It is now a counter offer. That is not so if you make any changes across any lines before signing it, that is a counter offer, and you are the new offeror, and the I guess whoever sent you that contract will have to decide whether or not they want to accept those new terms. Now, once we have both an offer and an acceptance, we have what is called a meeting of the minds, where the parties, if both parties have signed it, both parties are presumed to have understood the contracts that they have signed. That's why it is wise to seek legal counsel before signing a real estate contract, because you are presumed to have understood anything that you have signed. A party can seek to have a contract voided if a true meeting of the minds did not occur, such as they only signed because they were threatened by the other party or under duress or something like that. Now, the next element, so I'll call it element number 5, I think that's where we're at. We need to identify the parties. So a contract must clearly identify who the parties are. That's right. So it has to say the name of the buyer or the name of the seller. But when one of the parties is business, they must be signed by an authorized person. So make sure that only the authorized person can contract on behalf of a business. Number 6, a real estate contract must identify the property. Contract must be clearly identify the property. Generally, the address of the property is clear enough identification. Some contracts like to include the legal description of the property as well, but the address is generally good enough. Element number 7, contract must include federal and state specific clauses. Or they should contain them. They should contain federal and state required clauses such as lead paint warnings and or disclosure requirements that each state may have their own specific requirements that they want included in real estate contracts. And lastly, contracts need to have consideration. Consideration is a bargain for exchange. The large majority of the time, the consideration is money in exchange for real estate. However, it does not necessarily have to be money. It can be anything of value, such as my priceless legal services. Quick recap. So in order for a real estate contract to be binding, we need an offer and an acceptance. And once we have both of those, we have a meeting of the minds. We must identify the persons, identify the properties, and the contract should have, federal and state required clauses such as, lead paint or any required disclosures that your state may have, and consideration. So with that said, if you're looking to, sell your home, I can buy it from you with these priceless legal services of mine. So if you have any questions that you want considered for the Ask a Real Estate Attorney podcast, please submit a question by clicking on the link in the show notes. And thanks for watching. Take care.